Hi everyone, welcome to our webinar on preparing your business for success in 2024. My name's Olivia and I'm an associate in LegalVision's commercial and privacy team. I'm joined today by my colleague Saeidul, who is a senior associate in our employment and health and safety team. Before we begin, a couple of quick housekeeping items. So you'll receive the recording and slides in your email. You can submit your questions in the chat box and we'll aim to answer those today at the end of the presentation. And we'd love it if you could please complete the feedback survey after the webinar to give us some feedback on today's presentation. All attendees today are eligible to receive a free consultation with us to discuss how we can help you with your contracts or any of your legal needs for your business. So to request your free consultation, you can provide us with your contact details in the survey that appears at the end of this webinar. So on to today's presentation. So today we will be discussing a few different things. So your business structure, ensuring you have the right contracts in place, putting in place adequate intellectual property protection, understanding your privacy obligations, any employment law changes in 2024, and the company law changes for 2024. We'll also finish with a Q&A to answer your questions. As mentioned before, if you could please submit your questions throughout the webinar through the chat function and we'll aim to answer those at the end. We've also had a few pre-submitted questions as well. So I'm now going to pass over to Saeidul, who will talk about ensuring you've got the right business structure in place.
Thank you, Liv. So having the correct business structure in place is important to manage risk as a business generally, but it is also significantly important when it comes to growing your business. There are many ways to structure a business, such as sole trader route. So for instance, that would be individual trading under a business name, such as Saeidul Haque trading as SH Lawyers. There's also a partnership whereby two people are working on a business together without a formal structure in place, and they're legally determined to be in a general partnership. This means that assets are owned between them, but so are liabilities. You then also have more commonly a company structure. There are different types of company structures, but typically you will have a private company limited by shares. Most fast-growing startups choose a company structure. The benefits of a company structure include limiting the liability of shareholders. So if there was a claim against the business, it would be against the company rather than the shareholders individually or personally. It also offers you a degree of flexibility in the sense that it's easy to expand and that you can give away ownership rights in your business to key stakeholders. So that could be, for instance, your employees and or investors by simply giving away shares in your company. It also allows for a greater degree of tax planning as well, so you can choose who to pay dividends to as well. Other types of structure include a group company structure, and essentially this would be a dual company structure which consists of a separate holding company from the operating company. Now this can be beneficial when you have valuable assets for instance, a freehold property or any sort of valuable intellectual property. And essentially it's there that you want to protect in the event there was a claim arising against the operator company or if the business unfortunately failed. You may also want to have more than one operating company if it's appropriate for your business, taking into account the size of your organization. I'll now pass you on to my colleague to talk about the contracts for your clients and your team as well.
Great, thanks, Saeidul. So ensuring that you have contracts in place with key stakeholders is going to be incredibly important for your business. So, namely your suppliers, your customers, and your contractors. For your suppliers, contracts should include a clear description of the goods and services that you're purchasing and sort of what you're expecting for the price. There should be guarantees regarding the quality of the services, compliance with laws, etc., because there's very, very limited protection for implied terms in business-to-business contracts. There should be a requirement for a supplier to hold relevant insurances in the event that you need to sue and you want to be sure that they have the benefit of their insurance backing them there. any timeframes for performance if that's been agreed, and who owns the intellectual property that's created when you engage your suppliers for goods or services, particularly important in sort of a service-based contractor arrangement. So for your contractors, it's more sort of service specific here. Contracts should include, again, a clear description of the services being provided, the agreed payment terms, when you were agreeing to pay them, again, a requirement for them to hold relevant insurances, intellectual property ownership, and also really important that, if you've agreed certain obligations or contractual terms with your customers, that you pass those through to your contractors so that, you're passing through the relevant liabilities. With the current market conditions and the cost of living crisis, it's more important than ever to ensure you have a solid client agreement in place with your clients, whether they are businesses or consumers, setting out the agreed terms of the goods or services that you're providing. So some of these key terms which are really critical in the current environment are a price revision clause. So, inflation's obviously falling, but it's still very high. And so it's important to have a mechanism in your ongoing client contracts to revise the price at least annually. This price increase might reflect the CPI index or another amount. Sometimes it could be a percentage of the contract value that the contract can be sort of automatically increased by on an annual basis. Payment terms. So wherever possible, when you're providing goods or services to customers, obviously upfront payment is always going to be the least risky and preferred option. However, that's not always possible, particularly in certain industries. So it's extremely important to set out the payment terms in a written contract. So it should set out what happens if the customer doesn't pay. So, for example, do you have the right to suspend the services or terminate the contract if they don't pay? And what are your rights to charge interest and recover your costs in sort of recovering payment? For example, if you need to engage lawyers or debt collectors. Having all of this in writing will make it much more straightforward and easy to try and enforce your rights if there is non-payment. So much easier for you to sort of issue a letter of demand. And if you need to take things to court, having the agreed payment terms in writing will just mean that it's very, very sort of much more straightforward. As always, the contract should also include key provisions such as a clear description of the goods and services that you're providing to your clients, intellectual property ownership if that's relevant, always a limitation of liability, so aiming to limit your liability to your customers, and that will look different whether the contract is business to business or business to consumer, and what termination rights you and the other side have as well. If you're a business selling goods or services to consumers, you should be aware that the Digital Markets Competition and Consumers Bill is likely to become law in 2024, but not confirmed as yet. The bill, if it becomes law, will allow for greater enforcement of consumer laws, including rights for the Competition and Markets Authority, so known as the CMA, to enforce consumer laws directly. It will also prohibit online platforms from commissioning fake reviews. So it's very much a crackdown on fake reviews and making sure that there's an obligation on platforms to ensure that their reviews are genuine. And for subscription-based contracts, so a SaaS platform or other sort of subscription-based contracts, this bill will make it more straightforward for consumers to exit the subscription, including making sure that there's mandatory obligations for the service provider to notify people when their contract is coming up for renewal. So I'm going to pass back to Saeidul now to talk through intellectual property protection.
Thank you, Liv. So it is always important when engaging any employees or contractors that you carefully consider what this could mean for your intellectual property. Intellectual property, or IP for short, is essentially an umbrella term, and it's used to describe a range of legal rights that attach to certain types of information and ideas and to their particular forms of expression. So this could be through the use of trademarks, it could be through the use of patents, or even copyright as well. Having the right type of protection helps you prevent or even stop people stealing or copying the names of your products or brands, your inventions, the design or look of your products, things you write, make, or even produce as well. Now, typically, when it comes to an employment setting, anything created in the course of employment belongs automatically to the employer, and the UK legislation generally favours employers in this respect as well, particularly when there is any doubt over the ownership of IP. To enhance protection, however, there are certain measures that you can consider. So, for instance, you could include a statement of ownership of IP just to make it clear exactly who that belongs to from the very outset of the relationship. You could also have a contractual obligation to disclose information to you. So that'd be contractual obligation from the employee or contractor. You could also look at putting in place a restrictive covenant agreement, which would apply post-termination and protect your confidential information and to prevent solicitation and or competition. Now, when it comes to departing employees and contractors, they should always be reminded of any applicable post-termination restrictions upon their exit from the business. Seeking court protection should always be seen as a last resort, but it may become necessary if informal steps are not successful. Now, when it comes to pursuing these rights, time is always of the essence. So that essentially means if you want to go ahead and enforce them, you need to act very quickly to prevent the misuse of your IP rights or your confidential information. If you delay in acting, it could be a bar to injunctive relief and prevent enforcement or even any sort of remedy available to you as well. In order to be able to seek court protection, you must first ensure that you are not in material breach of the employment contract where the other party is an employee. Where this is the case, the employee could potentially seek to rescind the contract and all its clauses, including your IP clauses. Case law shows, however, that contractors do not have the same protection. Ultimately, if you have committed no material breaches and informal steps have not proved fruitful, you can always seek to pursue your rights through the civil court. But again, as I say, you should always look to that as a last resort measure, simply because of the time and potentially the costs involved with that as well. I'll now pass you back on to my colleague to talk about your data and privacy obligations for this year.
Thanks, Saeidul. So in the UK, obviously privacy is a key consideration for most businesses and is covered under the Data Protection Act, so also known as the UK GDPR, as well as the Privacy and Electronic Communications regulations, which are known as the PECR. So the regulator that enforces these pieces of legislation is known as the Information Commissioner's Office, so the ICO. In touching on what the ICO are sort of focusing their enforcement on this year, they're particularly looking at businesses' cookie compliance, the use of artificial intelligence, and the processing of children's data, particularly when online. And that's sort of with reference to the commencement of the Online Safety Act, which commenced in late 2023. In regards to cookie compliance, when you're using cookies on your website, you're required to get consent before placing a non-essential cookie on the user's device, so their phone or their laptop. This can be done by way of a cookie banner. So again, you've probably seen this many times as a user on websites yourself. You'll be asked to consent to the use of cookies before you can proceed through the website. In late 2023, the ICO assessed the cookie banners of the top 100 visited UK websites and sent notices to those businesses which did not comply with the PECR regulations around the use of cookies. In particular, the ICO noted that the cookie banner should ensure that non-essential advertising cookies cannot be placed on the user's device until the user has consented. So, they've responded to that cookie banner and consented to the use of cookies. and that users should be able to reject cookies as easily as they can accept them. So the ICO's guidance this year is certainly that it should be just as easy to reject all cookies as it is to accept all cookies. Spam text messages and emails are also a key focus for the ICO in 2024. Already this year, we've seen the ICO fine HelloFresh £140,000 for sending millions of spam emails and texts to their customers without clear opt-in, in breach of Regulation 2022 of the PECR. So it is important to make sure that you're getting adequate consent before sending marketing materials to individuals. Using generative AI in businesses is obviously a continual sort of growing concern for a lot of businesses in 2024. Although obviously the use of Gen AI comes with, increased productivity and efficiencies through automation, etc. It also sort of brings into question a lot of sort of legal issues, including the protection of confidential information that's being input into the generative AI tool, as well as personal data that's possibly put into the generative AI tool as well. The other thing is, who owns the content that is generated by the AI tool, and there'll be some interesting sort of cases this year that will come through, particularly the Getty Images case on this one. So the UK is not on track to introduce any specific AI legislation in 2024, but it is important to understand that there's already existing legislation in place that looks to sort of regulate the use and sort of help us understand the use of generative AI. For example, the Data Protection Act obviously governs the use of and processing of personal data, and we've got the Copyright Designs and Patents Act governing copyright law, as well as sort of relevant employment and liability laws as well. The ICO plan to release further AI guidance in 2024 regarding how aspects of data protection law should apply to the development and use of generative AI models in the future. I guess the key takeaway for businesses sort of using AI within their businesses this year, you should really consider, firstly, reviewing the terms and conditions of any generative AI platform that you use. Obviously, checking key things like, what they're doing with personal data, how they're processing personal data, who owns the input and output of personal data that's put through generative AI platforms. And, you should certainly be checking, their privacy policy, their data processing agreement, and ensuring that you've got a lawful basis, or they have a lawful basis as well for processing the data through the generative AI. You should also look to implement generative AI usage policies within your business to sort of govern how your employees use those generative AI tools, whether, there's restrictions, whether they can't put confidential information or personal data into those tools, to sort of stipulate some rules around the use of generative AI in your company policies. I'm going to talk to pass to Saeidul now, who's going to talk through some key employment law changes this year.
Thank you very much, Liv. So this year is going to be quite a busy one when it comes to employment law in the UK. So a number of changes have already been proposed and some have been confirmed to be taking effect. Most employment law changes take effect in April, and some of the key changes for businesses are as follows. So the first one is in relation to illegal working. So the civil penalty on an employer who employs an illegal worker has been increased from £20,000 to £60,000 per illegal worker, and that was implemented on the 13th of February this year. For a first offence, the maximum penalty is £45,000, and this rises to £60,000 for repeated offences. It is therefore very important that right-to-work checks are carried out on anyone engaged by yourself as an employer, simply to minimise the risk of being liable for the civil penalties and possible criminal sanctions, and to ensure that you have the statutory excuse as well. Secondly, looking ahead to holiday pay. So from the 1st of April this year, rolled up holiday pay, which is essentially the practice of a holiday being included in an employee's or worker's usual rate of pay, will be lawful again. This will be limited to staff who work irregular hours, such as casual workers or zero-hour workers, as they're commonly known, and also part-year workers or term-time workers. For holiday years starting on or after the 1st of April this year, statutory holiday for irregular hour workers and part-year workers will accrue at a rate of 12.07% of the hours worked in each pay period. Full-time or full-year workers with regular remuneration must still be paid for their statutory holidays at the point at which they take that holiday, and that'll be used in the typical 52-week average calculation. Now, while the changes are not mandatory and employers can still calculate holiday pay on an accrual basis, which is essentially where holidays are paid at the same time that they're taken, employers will now also have this option to calculate and pay statutory holiday pay on a rolled-up basis. But again, just to highlight that this is simply for part-year workers and casual workers and not for full-time or full-year workers. In terms of the next thing to consider, it would be family-friendly rights, particularly in relation to redundancy. So from the 6th of April this year, employees who take time off for maternity, for shared parental or adoption leave will have additional protection if their role is at risk of redundancy during that period of leave. The change will also extend the protected period to cover pregnancy and a period following the birth of a child or placement for adoption. The protected period will essentially mean that employees in these circumstances must be offered suitable alternative employment ahead of other employees who are at risk of redundancy. So essentially, if you had two people in the same situation and one had taken one of those types of leave, you're essentially going to have to offer the person that's taken the leave an alternative position ahead of the person that hasn't. So the regulations provide for the following. When it comes to maternity leave, the protected period starts as soon as an employee notifies the employer that they are pregnant, and it will usually end 18 months after the child is born, so quite a long time. Similarly, for adoption leave, the protected period will run from the date the child is placed with the adoptive family, and again that runs for 18 months from that particular date. Finally, with parental leave, to the extent that an employee does not already benefit from maternity or adoption leave protection, the protected period here starts on the date shared parental leave is first taken and again ends 18 months after that. Moving on to carers leave, from the 6th of April again this year, there will be a new day one right for employees to take 1 week's unpaid leave each year to provide or arrange care for a dependent with a long-term care need. Now, a long-term care need is simply defined as either an illness or injury, which can be either physical or mental, that requires or is likely to require care for more than 3 months. It will also cover a disability under the Equality Act 2010 or any issues related to old age. With flexible working, again, there will be changes made to this from the 6th of April this year. The key takeaways will be the fact that employees will be able to submit a request for flexible working from the very first day of employment. Previously, there was a qualifying period of 26 weeks service before employees could make such a request, but as of the 6th of April, that requirement will be completely removed. Other changes to the rules on flexible working include increasing the amount of times a request can be made from once per year to twice per year. And additionally, the period of time for an employer to consider a flexible working request will be dropped from 3 months to 2 months, and you will have a legal duty to consult with your staff about their request before making a decision. The statutory reasons for refusing a request, however, will remain unchanged. So, for instance, if you needed to refuse a request solely on the basis of additional costs, then you could simply look to do so. Still, there is a process that needs to be followed, but those reasons will still remain. Moving on to statutory duties later on this year. So there will be a new legal obligation placed on employers to prevent sexual harassment in the workplace, and that will be put in place from October this year. This new obligation will mean that employers will have a legal duty to take all reasonable steps to prevent discriminatory acts from occurring. It is therefore important that you review your policies ahead of this and ensure that your policies and procedures in relation to sexual harassment are adequate in light of the changes. You should also ensure that your employees are trained to recognize sexual harassment in the workplace and ensure that they understand how to report it as well. Failing to put in adequate measures and taking reasonable steps could mean that any damages awarded to an employee for a successful employment tribunal claim for sexual harassment could be uplifted by as much as 25%. Finally, there are also a lot of other changes that are expected in 2024 and possibly early 2025 as well. And that includes the introduction of neonatal care leave. So that'd be for stillbirths, for instance. There'll be a ban on withholding tips from staff for those in the hospitality sector. There will also be minimum service levels, so staffing levels during strikes, particularly for emergency sectors. There will also be changes to the minimum age for pension auto-enrollment and the usual yearly updates from April as well for the rate of pay for things like sick pay, the minimum wage, maternity pay, paternity pay, so on and so forth. Those rates are set by the government, and as I say, those change in April every single year. Now I'll pass you back to my colleague, Olivia, just to talk you through changes to company law this year.
Thanks, Saeidul. So yeah, also a big year for company law changes as well. So there's significant changes to UK company law in 2024, thanks to the introduction of the Economic Crime and Corporate Transparency Act. The first set of changes will be introduced on the 4th of March this year. So some of the key changes for businesses to be aware of are registered in relation to registered office addresses. So businesses will need to have an appropriate address as their registered office, meaning PO boxes will no longer be able to be used as a registered office address. And it also must be an address where any documents sent to the company will come to the attention of the person acting on behalf of the company, and which can be recorded by an acknowledgement of delivery. Importantly, for identity verification, so anyone setting up, running, owning or controlling a company in the UK will need to verify their identity to prove that they are who they say they are. So for new companies, all directors and people with significant control, also known as PSCs, will need to complete identity verification as part of the company setup process. For existing companies, all directors or equivalent and persons of significant control will have a transition period to verify their identity with Companies House. So it will also obviously affect existing companies. It will also affect anyone acting on behalf of a company who is sort of filing with Companies House on behalf of a company, who will also need to verify their identity before they can file information with Companies House. So obviously this affects accountants, lawyers, etc. In terms of fee increases, there haven't been any fee increases with Companies House for a little while. That will be changing in 2024. They say to sort of reflect the need for further funding to sort of fund the new powers and reforms that have set out in this Act. So they're yet to release what these fees will be or when they will come into effect, but something obviously to keep an eye out for. There will also be increased transparency required as part of this new Act, so including companies required to have a full shareholder list, which will need to be displayed on Companies House in a user-friendly way. Changes to the information that's required to be filed with each annual confirmation statement, and a transition towards filing annual accounts by software only rather than giving the options. So the options for web and paper-based filing will be removed. There will also be more effective investigation and enforcement powers for Companies House and new powers for Companies House to share data with law enforcement agencies and other government departments. So that concludes the main part of our webinar today. I'm going to pass back to Saeidul to discuss some other useful information, and then we will start answering your questions.
Thank you very much, Liv. So as shown on the screen, you might find this quite useful. and that is our starter publication as well, which you can download by scanning the QR code. Now, in terms of other events that we have coming up that may be of interest to you, we have one upcoming next month in relation to spam, cookies, and content, and also the legal considerations when leveraging digital marketing as well. We're going to answer your questions shortly, but while you do submit them, we'll take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of specialist lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team are specialists in their own field and can provide you assistance in varying degree of areas of law, and that would include unlimited document drafting and reviewing of business contracts, employment agreements, leases, so on and so forth. It would also include unlimited legal advice consultations and also unlimited domestic trademark registration and much, much more. We also offer a membership for in-house teams and general counsel to manage your high volume business as usual legal tasks. To learn more about how our membership can help you, please request a free consultation when the survey appears at the end of this webinar. And now we move on to answer some of your questions. So we can see that a couple have been submitted. So let's have a quick look through just to filter through these. Okay, excellent. So looks like one of the questions that has been asked is, what are the best steps for a startup in terms of contractual agreements for employees and vendors? So that is a great question to be asked. So it is always important to consider putting in place a contract for peace of mind, as it clearly sets out your expectations as an employer, and there would be no ambiguity over this. When it comes to considering contractual agreements in an employment setting, the first thing that you must do is take a step back and consider what employment status is right and best for your business. There are three main types of employment status, and these are employees, workers, and the self-employed, who are also known as contractors. Each of these types of employment status come with their own rights and responsibilities, but in short, employees have the most protection and would be entitled to employment rights, such as the right to a minimum wage, to pay slips, to a contract of employment, and also pension contributions as well. Workers have most employment rights as well, but not all employment rights. And then with contractors, they simply have no employment rights, but that's not to say they have no rights at all, because they still are given protection from discrimination, and you also still owe them a duty under health and safety laws. In the same vein, if you were to pay, if you're not to pay them rather, then they could potentially take you to civil court as well for breach of contract as well. Now, given that employees and workers come with employment rights, a lot of startups prefer to engage contractors, at least initially. Often this can be a cost-effective approach at the start when cash flow might be an issue or it might be tight. Later on, you can always decide to engage the contractor permanently and then look to set up your payroll. If you do decide to engage employees or workers, you are legally required to put in place a degree of measures, including a contract on or before the first day of their employment, along with other factors such as setting up your pay-as-you-earn scheme through HMRC, employees' liability insurance, and also setting up a pension scheme as well. When it comes to business transactions, we would also again recommend putting in place a contractual agreement, as not having a contract in place can lead to ambiguity of how a matter should be dealt with, such as delay in providing services or even dealing with termination of a contract. Having an agreement in place would always ensure everyone is aware of the rights and obligations from the very outset and also provide legal certainty. It would therefore be prudent to seek legal advice when starting a business to ensure that you meet your obligations and also put in place measures to protect your business. I can see there's been a couple more questions, but I'll pass one of these on to my colleague.
Thanks, Saeidul. So I could see that there were a couple of questions which I might try and tie together and answer at the same time. So the first one was, how long does it take to obtain funding, and is there any way to speed up this process? And the other question that we got was, how can I expand my business? So yeah, I'll tie both of those together, as funding is generally sort of the key way to expand your business. So sort of answer that one as well. In terms of how long funding takes, it depends on what funding as a business you're considering. So whether that's equity financing or debt financing, I'll touch on both of those in a second. Um, and the question is kind of really becomes sort of how long is a piece of string, really. So it's a difficult one to give you a sort of an exact time frame on. Um, and I guess I'll sort of tell you why. In terms of debt financing, so if you're obtaining a loan from the bank or another lender, the length of time will often just depend on their approval processes, and sort of the bank's process in respect of sort of getting the money to you, approving your application, etc. Alternatively, for equity financing, it will depend on who you're looking to get the investment money from. So if you're looking to get an investment from friends or family, and usually that's in exchange for shares or share options, this will generally be a quicker process to agree sort of the key terms and receive the funds. Usually your friends and family won't be doing too much due diligence, and they probably won't require extensive documentation to be put in place. However, if you're looking to get equity or funding from a venture capital firm or another sort of professional investor, you can expect the process to be, a fair bit longer in the sense that they will want to be undertaking more comprehensive due diligence. They'll require sort of further documentation from you, and they'll typically want to negotiate longer form documents, ask you to take on certain warranties in respect of sort of the information you're providing, and sort of undertake, usually legal review of those documents back and forth as they're negotiated as well. So in terms of other options for expanding your business, you can also consider things like grants, seeing if there's any incubators out there that can sort of support you. Depending on what your business does, so sort of what you're selling, you can also consider other business models which require less capital for expansion. So, things like a franchising model, for example, for where you're selling goods or services as well. Whichever way you choose to expand, always do that in a sustainable way, just to ensure that the business, can grow sustainably and sort of continue that growth as well. All right, looks like I'm going to pass this one to Saeidul, the employment expert. So the question says, you mentioned changes to pension auto-enrollment. Can you elaborate on this, Saeidul? Are you okay to take that one?
Yes, thank you, Liv. So, that's another great question. So the current rules on pension auto-enrollment stipulate that for someone to be eligible to receive pension contributions, that they must be classed as a worker. So that'd be when we're looking at employment status. They need to be aged at least 22 and over and under the state pension age, which does change depending on the year that you're born. And you must earn at least £10,000 per year. And finally, you must ordinarily work in the UK as well. If you don't meet any of those requirements, then simply a person would not be eligible to be automatically enrolled. There are some proposed changes to this legislation, and that did receive royal assent on the 18th of September last year, and a consultation is going to be launched to implement the new measures. But looking at the two main changes would include lowering the qualifying age from 22 to 18, so effectively when someone departs from college, and then also removing the lower earning limit for qualifying earners. So someone would no longer need to earn at least £10,000. It would be potentially available from the very first pound that they earn as well. There are currently no plans to change the level of contribution or the minimum level of contribution from an employee or employer, which is currently 5% and 3% respectively, but it is something to keep an eye out on as well in case it does change. I can see there's one final question here as well about the implications of receiving a grant for innovative tech products. I'll just pass you back to my colleague Liv, who I'm sure is best placed to answer that.
Thanks, Saeidul. A lot of our clients come to us once they've received a grant, and it's obviously really exciting and a great way, obviously, to inject some cash into the business and, hopefully bring your business plans to fruition. So when you receive a grant, there will generally be terms and conditions which attach to that grant. So you'll receive some sort of grant agreement from whoever is funding the grant. Now, these terms and conditions will include things like what you can use the grant money for. So, and that'll usually be quite specific as to what you can use the grant money for. And often, yeah, it locks you into the project that you've obtained the grant funding for. So obviously you need to be obtaining grant funding for the projects that you're obviously looking to fund, not other projects. Now, in these terms and conditions, there will also be other terms such as intellectual property ownership. Sometimes the funder will ask for a license to the intellectual property, perhaps to use for their own commercial purposes. Perhaps there might not be an intellectual property license or any sort of intellectual property transfer of ownership, but that's obviously a really, really important one to make sure that we're checking, because obviously you don't want to sort of get this injection of cash and then realize at the end of it that you can't commercialize or own what you've created. Now, there'll often be reporting requirements in there as well. So requirements for you to report sort of what you've done with the funding and keep the funder up to date, and conditions around how you can obtain other funding. So it might say in the contract that you can't obtain funding elsewhere, or you need the consent of your grant funder to obtain sort of funding elsewhere, whether that's from a bank or other sorts of cash injections. So again, just be aware of those types of terms. And also really importantly, you need to be aware of conditions of repayment of the grant. So for example, if you're in breach of the contract or, there's certain conditions aren't met, you might be required to repay the grant. And you also need to be aware of the rights that the funder has to terminate the grant as well. So, if they can terminate the grant in their discretion, or if certain conditions aren't met, you need to be aware of all of those things so that you can do your best to obviously avoid that from happening. So obviously, totally recommend that a legal professional reviews the terms and conditions for your grant so that you understand what you need to be doing under the terms and conditions for the funding, and so that you can abide by these and obviously look to maintain that cash and use it really wisely for your business. Great. Well, that was good timing. I think that's all the questions we have and also all we have for today. So that timing lined up very well. After the webinar ends, a survey is going to pop up. We'd really appreciate it if you could complete the 30-second survey. Please include your contact details and we can book you in for a complimentary legal consultation to discuss how we can help you with preparing your business for success this year. And yeah, thank you so much for joining us. We've hoped it's been really useful.
Thank you very much. Goodbye.